This conference will now be recorded.
So good afternoon, ladies and gentlemen. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our April 15, 2021 public meeting. This meeting is being held via teleconference pursuant to Governor Cuomo's Executive Order 202.1 due to the coronavirus emergency. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of interim multi-dwelling buildings from commercial and manufacturing spaces to safe rent-regulated residences, which comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. We have a new member joining us today, Kei Hayashi, as well as a new executive director, Kevin Schultz. Kei Hayashi is joining the board as the representative of manufacturing interests. Kei is happy to join the board. She spent 20 years in the federal and New York City government focusing on economic and industrial manufacturing policies. In 2010, Kay formed a real estate and economic development firm. She's on the the Brooklyn Navy Yard board, still a part of the New York City industrial community, and lives right here in Brooklyn. Kevin Schultz is joining the Loft Board as a new executive director and general counsel. Kevin Schultz is admitted to practice law in New York since 2006. He's a native of Central Illinois. He migrated to New York City with his interest in law, sprouted from his fascination with New York City itself. He chooses a legal career specifically to become New York City government attorney. And Kevin interned with New York's Law School Center for New York City Law during all 3 years of his law school career, writing for City Law, City Land, and City Admin. Upon graduating, Kevin received the center's postgraduate fellowship, where he worked full-time for over a year researching and reporting on significant land use and municipal law developments in the city. Kevin's work with the Center for New York City Law cemented his interest and enthusiasm for city government. And in 2007, Kevin began as an agency attorney with the New York City Department of Buildings, Office of Internal Affairs and Discipline. He worked with IAD for 14 years, ultimately serving as the unit's deputy director and also serving as acting director on some occasions. Kevin is tremendously enthusiastic to now be working with the New York City Loft Board and his staff on the board's important, unique, and challenging work, as you all know. So I just want to say a special welcome to both our new board member, Ms. Hayashi. Ms. Hayashi, can I call you Kay?
Please do. Thank you.
Thank you. Thank you. Welcome, Kay, and welcome, Kevin. Kevin, we know each other and work with each other. Have been working together now for the past 7 years or so. So, Ms. Kay, would you want to say anything at all?
No, just thank you very much for welcoming me, and I hope you'll all have some patience as I learn the procedures and the rules, and I look forward to working on these important issues. Thank you.
Thank you. In that regard, please have some patience with me too. So, you'll hear from Kevin soon. So the first order of business is a vote on the January 21st, 2021 meeting, the minutes of those meetings. Are there any corrections or comments on those minutes? Mr. Delaney, you have the, go ahead, sir.
Thank you, Mr. Chair. There are not too many. On page 8, in the middle of the page, we're talking about one case at 475 Kent, and the text middle of the page reads, Mr. Delaney moved to accept these cases. And in the following sentence, Chairperson Hilton asked, is there any comment on the cases? In both cases, that should be singular rather than plural.
So this is, you're saying it should be accept this case.
Correct, in two places.
I seem to remember that. Yep, correction. Thank you.
On page 11, middle of the page, the first paragraph on self-certification, the last sentence begins, the summary is go due to Ms. Rosalind and Ms. Torres Moskovitz. And it should be the summary is good due to Ms. Torres and Ms. Moskovitz.
Acknowledge. Thank you.
And one more and a question, page 13, 2/3 of the way down the page, again, we're talking still about self-certification. I agree, and obviously irregular construction of residential units, that should be in regular construction of residential units. The point being that in the loft world, we're dealing with construction in occupied units rather than in the real world where generally new units are built and are vacant until the certificate of occupancy is issued. And in the next paragraph, Ms. Rosalind, line 3, there's so much minutia. I think minutia needs an E at the end. And that's it. Other than there is reference in the minutes on page 4 to my asking if there was any update on the executive session we held in November on a pending legal issue. So I'm just asking again if there's anything to report on that.
Kevin?
Yeah, we reached out to the law department on that case this week, and we're told we'd hear back from them this week. And Tina, if there's an update I missed, let me know. But as of today, we haven't heard back. Is that correct? Okay. So the inquiries. What's that?
The week's not over.
Yeah, exactly. So they still have time. Absolutely.
So an update is imminent, you're saying, Kevin, from them?
Yes. And to the extent it doesn't come, we'll be, politely asking them if and when it's coming.
Okay. And the plan for circulating, any plan for circulating those, anything from the law department, any information to board members?
When we see it, it's possible we would circulate via email for individual comment, and then talk about whether another session is necessary, and presumably vote on that next meeting if we need to vote on it.
Yeah. Okay. Great. Page. Oh. Thank you. Are there any other comments on the minutes? Thank you, Mr. Delaney.
You're entirely welcome.
Okay, absent any comments, Ms. Rivera, could you please poll the board members?
Motions.
Oh, I'm sorry, I need a motion. Mr. Delaney and Mr. Bowers is second. Please poll the board members.
Mr. Bauer,
Yes.
Mr. Roche,
Yes.
Ms. Hayashi,
Yes.
Mr. Delaney,
Yes.
Ms. Roseland,
Yes.
Ms. Rajan,
Mr. Jean, I think we're something with your sound, Mr. Jean. Could you? She's indicated this for the record. She's indicated yes, but I still am not hearing you. So, is anyone hearing Mr. Jean?
No.
So just check your sound. Try again, Mr. John. No, yeah, you may want to just double check your sound, but we've indicated that you're saying yes.
Chairperson Hudson,
Yes.
7 in favor.
I just want to also,
Mr. Chair, is there any reason why we didn't get the March minutes?
it's not complete yet. Is that what it is, Terry? Is Terry on?
Sometimes
That's correct, yeah.
it's difficult to go back and try to remember what was going on 2 months ago. That's my only point.
Yeah. So, yeah, just bear with us. I mean, this is it's a little rough. I understand, but yeah. But you remember, we'll send it to you a week in advance. So, and you just have to trust me. Thank you. Okay, I did forget to mention one thing. Miss Nicole Otto, who is our public member, was supposed to join us today, and also, did I mention that she was not going to be able to do that today because of a conflict? So I know I'd announced that last time that she'll be joining the board this month, but that is not going to be the case. But she will be with us next month.
Ronaldo,
Yes,
can you give us any kind of thumbnail biography?
sure. Kevin?
Ms. Otto, I think we'll get a proper biography when she's here, but she is an accountant. She's worked with nonprofits a good part of her professional career. The firm she works with does accounting, I believe, exclusively for nonprofits. That's their niche, and they do it in a way that makes it doable for nonprofits. Beyond that, that's what came to mind right away.
Okay.
There's much more.
Okay, no problem. Actually, Kevin, I wasn't suggesting you should remember all the.
I'm sorry.
What we'll do is we'll ask Miss Otto for her bio, and we'll forward it to the board members in an email. Is that okay?
That'd be perfect. Thank you.
Actually, she's a member of the board already, so she'd also be on that email.
Okay, I just want to make something for the record, even though it's certainly out of our jurisdiction. But there are 2 members of this board that has any history of loft living. And I think 2 out of 9 is really not the right number. But of course, I have no jurisdiction over this. But I just want to make this clear that I feel thusly. Thank you.
Okay, thank you, Mr. Bowers. Okay, so the next item on the agenda is Mr. Schultz's report. Mr. Schultz, could you go ahead and make your introduction and do your thing? Thank you.
Yeah, thank you, Chairperson. I want the first thing I say is to be expressing my appreciation for the Loft Board staff. They deserve the compliment publicly because for the last year they have been working on the Loft Board's important work without an executive director. And Loft Board's work is challenging in the best of circumstances with the most available resources, and they have successfully moved along the board's business. And some of the folks you see on these meetings, but a lot of them you don't. So both the ones who are on this meeting and the ones that aren't for the last year have just been doing an amazing job. And then I showed up, and they have so kindly and patiently and diligently and skillfully worked to onboard me. So I would be remiss if I didn't start with that appreciation and that recognition that they all deserve. They're a team in the truest sense, and I'm honored to join that team. I really am. They're just we all owe them a lot for their dedication in the last year and in the coming year, as I know we'll all see. I also want to thank everyone here on the board members also for in advance for helping me make this transition onto the Loft board. And I'll be relying on your expertise as we go forward. And I've spoken with most of you already one-on-one, which was wonderful and enlightening. And I look forward to more one-on-one conversations as much as you'll have me. And from that, and from speaking with the board staff and joining other public meetings and listening to these meetings for some time, even with all that, it's probably too early to have a clear vision of exactly what the goals and priorities would be while I'm here. But I certainly can identify a few things that I do want to bring up, and one of them that we'll be talking about a good amount today is rulemaking, and that I think. I won't be able to claim much credit for the victory, but we're very close to finishing the rulemaking, and so that will be a big milestone that I'm just glad to have been here for. But the credit will go to all of you who are here before me. And I've heard another item that I want to make sure I mention is because I've heard it so many times is enforcement. Enforcement is the tool that helps us toward one of the tools that moves us toward our final goals of legalization. It also helps keep people safe and healthy, and so that is something that it's been identified to me. I shouldn't say I identified it. It's been identified to me several times as something that to work toward, being ever more effective in. Two more notes to that point. Another one that I've heard about a few times is just our public face and our accessibility to our constituents, tenants, landlords. And, amongst those things, a lot of that's already in place. The website, I think, is very good. I think our processes and forms are excellent. The rulemaking itself is in that direction. We're trying to make it simpler for people and more accessible. But certainly letting people who need us know we're there, it will always be a priority. And the last priority is so evident, but I'd be a fool not to mention it. It's the legalization itself. It's getting these buildings across the finish line. It's easier said than done, but with the things I mentioned and I've heard about and so many others, we're going to get there with these buildings. May we put ourselves out of business by successfully transitioning all the buildings, and then maybe we'll get more customers. That's all by way of introduction, other than to say I'm very honored, I'm very excited, I'm very enthusiastic, and I look forward to this meeting and many others. From there, I'll go into the normal stuff you hear about from the executive director. Due to the ongoing public health crisis and in accordance with the governor's executive order 202.101, the suspension of required in-person board meetings has been extended through May 6th, 2021. So that doesn't tell us much about our next meeting yet. So stay tuned for what happens with our in-person versus virtual meetings. Revenue, the unofficial Loft Board revenue for March 2021 was $13,150. In the month of March, we issued 2 violations. On March 19th, 2021, one violation was issued at 525 West 45th Street, Unit 3C, here in New York for no heat, New York, Manhattan for no heat. March 29th, one violation was issued at 83 Mesrel Street, that's also known as 132 Leonard, in Brooklyn for no gas and partial electricity. And there's one litigation update, and that is a case, it's a decision in a case Amicus Associates LP versus the Loft Board, New York City Loft Board. And in this case, the owner had filed an Article 78 challenging this board's determination from September of 2019 in a Loft Board order. And the then executive director, the order supported the then executive director's denial of an owner's second request for an extension related to code compliance deadlines. And the court here dismissed the owner's petition and found that the Loft Board's denial was rational. The owner had failed to demonstrate the circumstances required under the statutes, that it was beyond his or her control and in good faith. And the court also denied the owner's request regarding there was an argument by the owner that the loft board executive director could issue multiple extensions, and that argument was rejected by the court as well. And finally, also the court rejected the claim that this board had improperly discussed the matter in an executive session. There was no evidence of the executive session that was alleged, and the court finally determined that the rules as we have them written are not I'm sorry, let me rephrase that. The board's decision was not beyond its authority in the loft board order that it issued, and that is a decision under the litigation. I think that is the last point of the chairperson's, I'm sorry, the executive director's report. Thank you very much.
Thank you, Mr. Schultz. That was well put together. I appreciate that. Does anyone have any questions of Mr. Schultz? I guess, Kevin, you did good. That good. And
all right. They're being kind to the new guy. I'll take it.
All right. Very good. Thank you. And welcome aboard, Kevin. I appreciate it. And
thank you.
Your preparedness. Kevin, by the way, has kept abreast. He's had his approval has been in the works for months, almost a year, and he's been keeping abreast on his own of, just to familiarize himself and working with staff, even though he was not officially on board. So that's really great and commendable. I appreciate you coming on board so well prepared. I wanted to say, especially to Miss Lynn, for her taking the reins of the loft board for these months and coming in at such short notice with the loft board and maintaining the level of professionalism and hard work that has kept the loft board functioning right through even the pandemic at a difficult time. I don't know if you remember, but Miss Lynn had just been with us in, what was it, February, before the month before the pandemic, and so she got pretty much baptized by fire, in the work of the loft board and doing it in such a great time during the very challenging period. So thank you for holding it together and keeping the staff operating right throughout. And to all the staff, of course, they all did great. So thanks again, Ms. Lynn, for your leadership there. Okay, the next order of business is Mr. Delaney's last month, March 18th meeting. Mr. Delaney had requested 10 minutes. I hope I didn't catch you off guard, Mr. Delaney, but you had requested 10 minutes on this to talk about this issue. So I'll now turn it over to you if you're prepared. If you're not, then we can always move on.
I'm prepared to kick the can down the road in the sense that since Nicole Otto is not able to join us, it would seem to me that having a discussion of significant length on the topic would probably, under the circumstances, better be left till next month. So I guess we slide back a month. For our new board member and our new executive director, I would just point out that the issues involved are summarized very well in the November 2020 meeting minutes and the January 2021 minutes that we just approved earlier today, and that this initiative, which stems from a letter that was written by former board member Julie Torres Moskovitz several years ago, is really focused around the fact that there have been some egregious examples of very dubious behavior on the part of some practitioners involving a significant half dozen that I know of and can could rattle off the top of my head. Loft buildings where certificates of occupancy were issued when there were clear conditions that should have prevented that, and therefore the general idea is that it would be good to request that the Department of Buildings make it a regular practice to look into self-certification positions, filings, I don't know quite how to characterize them, in IMD units as a matter of course. We learned from Mr. Rebholz from DOB that they audit about 20% of all self-certifications and professional certifications. They always audit when there's a complaint, but of course, a lot of times a tenant in a loft building is not going to know that something has gone amiss. And I think relying on complaints as a way to treat this issue is not sufficient. And if we did ask the Department of Buildings and they agreed to look at all cases of professional self-certification in IMD buildings, it wouldn't eat up a significant portion of that 20%. So it's not like we'd be elbowing everybody else out of the way. So that's the general thought behind my intention to draft a resolution for the board to vote on. And if it was approved by the board, it would ask the Department of Buildings to make that a practice. Period.
Thank you, Mr. Delaney. So, Kevin, we're going to have a formal presentation in our May meeting of Mr. Delaney. Mr. Delaney, are you planning on the resolution at that point also? On the following one?
I think it would probably be useful to have it available for review at a minimum, if not a vote, so that I will commit, which I've done a number of times, but circumstances keep changing. But I'll have something that I will send to the executive director at least 2 weeks prior to our May meeting.
Great, thank you.
If anybody has any questions or comments at this point, I'd be happy to entertain them.
Okay, thank you, Mr. Delaney. I appreciate that. Okay, so we now turn to vote on the cases. So there were 11 cases on the summary calendar, and they're voted on as a group. These cases are, and I would just say that all 11 cases are the same applicant, 475 Kent Owner LLC. So I'm not going to read the applicant's name and address all 11 times, but I'll read the docket numbers. So 475, on all 11 cases, there are 475 Kent Owner LLC, and in all 11 cases, they are 473 through 493 Kent Avenue in Brooklyn. The first docket number is LS 0257, then LS 0265, then LS 0266, LS 0267, LS 0268, 0269, 0270, 0271, 0272, and 0273, and 0274. Is there a motion to accept these cases?
So moved.
Mr. Hilton is moved. Is there a second?
A second.
Ms. Roslin. Thank you, Ms. Roslin. Okay. Does anyone want to comment on these cases? Absent any comments on these cases, Ms. Rivera, could you please poll the board member?
Mr. Bauer,
Yes.
Mr. Roach,
Yes.
Ms. Hayashi,
Yes.
Mr. Delaney,
Yes.
Mr. Hilton,
Yes.
Ms. Rosen,
Yes.
Ms. Rajan,
Okay, Ms. Rajan still has no sound, but I can see she's giving me a thumbs up, correct? And she's voted yes.
Chairperson Hilton,
Yes.
8 in favor.
I'm sorry. Can I just go back? Because before there was 7 in favor. So is that 8 on the
Yes.
clerk, on the minute, on the vote of the minutes? There was 8 in favor, not 7.
Well, no, I didn't call Mr. Hilton.
Oh, Mr. Hilton's name was not called, I think, on
Yes.
the minutes. So, Mr. Hilton, do you concur on the minutes?
Yes.
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 So just point of correction. Thank you very much. Okay, there is one case on the master calendar, and it is a removal case. So there's no staff presentation, sorry. The case is K Plaza LLC, and the address is 79 K Street in Brooklyn, New York. The docket numbers are LE 0721 and RG 0210. Do I have a motion to accept this case?
So moved.
Ms. Hayashi has moved. Is there a second?
Second.
Mr. Bar, I'm sorry, Mr. Hilton, I heard, I'm sorry, Mr. Hilton. Is there,
Chair,
any?
Can
Yes,
I just interrupt? There's a note in chat from Ms. Rajan that she'd like to exit the meeting and
and
return.
rejoin? Yes, go ahead, Mr. John. Just give me a second, please. Mr. John, can you hear me?
I can hear you. Can you hear me now?
You're perfect. Thank you.
Okay, great. Thank you.
All right, we're back on the record. So I think I was asking if there are any comments on the K Plaza LLC. Absent any comments, then Ms. Rivera, could you please poll the board members?
Mr. Barrett,
Yes.
Mr. Roach,
Yes.
Ms. Hayashi,
Yes.
Mr. Delaney,
Yes,
Mr. Hilton,
Yes.
Ms. Rosen,
Yes.
Yes.
Ms. Rajan,
Yes.
Chairperson Hilton,
Yes.
8 in favor.
Thank you. So that was Kevin, congratulations. I don't know what I would have done without you. We're just speeding right through these cases. Appreciate that. All right, Kevin, thanks for bringing your magic. So the next item on our agenda is rulemaking updates, right? And Mr. Clark, who's been doing this fantastic job, is going to lead this discussion. So does anyone need a break before a 2-minute break, just before we go into this these discussions? No? So Mr. Clark, you have the floor, so to speak.
Thank you, Chairperson Hilton. I just want to make sure everybody can hear me okay. Good, okay, thanks. So the first thing that we want to do is we want to, we have some updates for the board. We had The first update was actually from the outline that we were working on last month that we're going to also continue to work on this month, but there was a question specifically about item number 3 on the outline. That question was about the table of contents, and there was a question as to why the table of contents was deleted. And we went back, we received an email from the law department, and basically the law department stated that the table of contents wasn't needed. So it said specifically there's no need to create a table of contents, especially since the official rules are online. So that's the reason why the table of contents was deleted, and we wanted to just let the board know that was the reasoning from the law department.
So in other words, go ahead, Mr. Delay.
I think I was questioned that, and if I understand correctly, the position of the law department is that it's not needed, not that it could not be included.
Yeah, that's what the position is from the law department.
So Mr. Delay, what I was going to say is I think the law department is opining on standard rulemaking practices that are probably happening in today's days. So if they're saying that's what it is, that probably means that nowadays in rulemaking there's no table of contents on these rules. So I don't know if you have any clarification, Kevin, on that.
I haven't spoken with law department. There was an email that I saw. I'll just go from my at least one upside to not having the table of contents, and it's less content with which people might use to try to change the meaning of our rules. Having a table of contents, even if it's perfect, but maybe if it's not, just is another place where people might try to utilize an argument, to be honest. So I think often less is more, and so I again didn't speak with the law department on this point personally, but I could guess that part of the thinking is table of contents is another area in which parties who are looking to use the rules in their favor might find something there that they could use. So not having one is one less place.
Okay, Mr. Delay.
I can see the argument on both sides. And as someone who spends a not inconsiderable amount of time referring lay people to sections of the rules, I can definitely see reason why having a table of contents is helpful for lay people. But I also, if I understand the inference, is that the problem is the sharks try to use it to mess with things. And we've certainly seen some pretty remarkably conflated arguments recently about small points. So I guess there's good reason to not include it. And I guess it would, I guess what I would do in that case is just create my own outside the document table of contents to help guide tenants through, because if you want to know the rules of access or what should I expect at a narrative statement conference, and the answer is, here, pal, here's 200 pages. Lawyers are $500 an hour. You figure it out. Is neither user friendly nor transparent. But I gather that maybe that's best left. Maybe that's just something I need to create as a concordance, so to speak.
Yeah. So if you want us to just Mr. Clark, I would just ask you to just revisit it with law and find out if this is something that they are strongly opposed with, like meaning that they would not give us final approval of these rules without it, or what? Is this something, is it something that they have decided citywide that this is never going to happen in modern rules, or is just something that he feels strongly about. So you guys can just get back to us by next month on that. Apart from that, the table of contents that exists right now that was deleted, maybe Mr. Delaney, you have a head start on those on that summary that you need.
Yes, I agree with that.
Right. Okay. I appreciate that. So, Mr. Clark, go ahead.
Sure. And so the second update is from our last discussion when we were talking about the notices from Oath with respect to the Loft Board. If we accept Oath's procedural rules, and obviously we made the carve out so that the Loft Board will be mailing the notices. There was some interest in how the transition will take place if and when that day comes when the Loft Board will be responsible for mailing out the notices. So Executive Director Schultz was kind enough to reach out to Oath and have a discussion with them on what it might look like if the Loft Board had to bear the burden of mailing out notices. And I will allow Executive Director Schultz to speak on that.
Thank you, Mr. Clark. So just to get everyone up to speed, according to our rules, the Loft Board is responsible for certain notice requirements, the Loft Board staff more specifically, of course, and the Oath, their staff have been benevolently been handling that for us. So if any of them are listening, thank you, and much appreciated. But in rulemaking, changing it to their responsibility wasn't realistic to them, very understandably. So as we confronted this as a group, or you did, I wasn't here yet actually. I think appropriately the question was risen: how do if this happens, what's it going to look like? And the answers are hopefully fairly simple. The Oath will give us a heads up. They will talk about a time in the future upon which a transition will happen. They will provide us with examples and templates and that they use for the various scenarios. I'll add to all of this that we, as different units and different agencies, have a fantastic rapport, a very good relationship, excellent communication, with some history and related connections. So, of course, a certain amount of this is going to have to come down to, are they going to do this fair and right? And I have every reason to know that they will. If it happens, we don't want, we appreciate them doing it, and they're doing it so well. But because the board, I know, wanted to, not let anything hit us unexpectedly. It was a very positive conversation where it was clear that if they had to do this, they would do it with a kind approach, with an understanding that it would take some time to transition with a future date. Once it happens, we'd have the examples and templates they use, and this is about notice of hearing dates at Oath. The Oath calendaring staff would still communicate with the parties to get the dates. We would not be interacting, trying to coordinate schedules. Oath has a calendaring unit that will do that. And then essentially they'll share with us the dates that are determined in the same way they'd share it with their unit that currently sends out all the mailings. We would prepare the documents and put them in the mail according to our rules if that responsibility was transferred over to us. The parties that would receive it, we would have that information because we receive the list of affected parties on the application, and we give it to Oath. So we would have the parties, we would have the form templates, and we get the dates from Oath. And again, Oath assured that if this were ever to transfer, it'd be smooth, communicative, patient, kind, respectful, not a like your problem kind of thing. And I do trust the people there, and have every reason to think they'll be there, as will we. I hope that answers the question. If it doesn't, I'm happy to, hear other thoughts and try to either answer it or get the answer.
I've said this before. I know Mr. Delaney is about to say something, but I've said it before to the board members, and I'm going to repeat it. The Loft Board is a city agency, and so is Oath. it's a court, but it's a city agency. There's no way that another city agency is going to just be able to come out of a responsibility or a dump, something like that, that affects another agency without some coordination through the mayor's office. So I completely trust, as Kevin says, that in any transition, this will be a smooth one, and there will be time to make this happen, to make it happen. So trust me, you know, this will not, we may not all be here when this happens, but when it does, it will never be a dump jeopardizing any of these cases. Go ahead, Mr. Delaney. I think you had some.
I was just going to thank the executive director. That's a significant piece of information because from my vantage point, one of the key questions was the calendaring piece of this, which would seem to require knowing the oath judge's schedule as well as the parties and how many times would we be calling back and forth. But if they're going to continue to do the calendaring, and in essence, we're going to become the mailroom, that strikes me as a more workable, you know, I'll leave it there. Thank you.
And it's consistent with the rules that way. It's totally, you know, the rules don't say we have to calendar, and you know, with chairperson's right, with the kind of the mayoral assurance that they're not going to try to push more off than we're required to do. So yes, I think I thank you. That is a key distinction.
Ms. Clark?
Thank you, Executive Director Schultz. So the next portion of the rulemaking is going to be, there was a document that was sent out to everyone. At the top of it, it says Section 3, Subdivision B of Section 2-01. That is the extension rule. So I'll give the board members a few moments to get that document. And this document is, again, about the extension rule. The board members recently had a vote with respect to the extension rule. There was a modification to the current rule in the proposed rules, but the board members voted to go back to the current rule. So we're modifying the work that we had in the proposed rules and just going back to the current rule, but we also had to make some changes in the current rule, specifically for the global definitions. You'll see that they're capitalized. That symbolizes that it's been defined in our global definitions. Also, we added a couple of sections in there which basically just correlates to the change of the law, 281.6. We had to include that in the rule. And also highlighted in pink, there are two deletions. The first one is the removal of the definition of new owner. We removed that because it's already defined in the global definition. And the second deletion is pertaining to where an owner can get an extension, simply because of the change in the law that shortened their time for an extension by 6 months. We decided to delete that because the owners that could have taken advantage of that particular section, that time has long expired, and it's not realistic that any owner could actually get an extension under that particular rule. So the board members has.
Is that realistic, or is it not possible?
It's not. I'm going to say not possible, but I'm
okay.
Deputy General
Why is it
Counsel,
not possible?
who is an expert at catching minor details.
I think Mr. Hilton,
with a scenario where that might be possible, but I can't think of one.
Okay, Mr. Hilton, I'm sorry, I recognize Mr. Hilton, he had a question.
Yeah, I was saying, so why is that not possible? Run through that with me.
Well, I'm gonna allow Deputy General Counsel Tina Lynn to respond first, because I don't want to confuse everyone with my.
Yeah, so I don't know if it's like not legally impossible. I wouldn't say it's not possible. Just the rationale that this rule exists in the first place is no longer applicable. At the time, this applies to a short name extension back due to a change in law in 2012, 2013. That's a very long time ago. I'm not sure if the board would have a rationale to offer those owners who would prejudice by the 6-month shortening another opportunity. Of course, if board members disagree, we can certainly discuss it, but it seems like the time for that, the reason for granting that extension has already passed.
Okay,
And yes,
I just want to go through it again.
Right, and
Maybe
I would
we'll
have
look at
added that
I'm sorry.
the rule requires.
Stephen, just 1 second. Mr. Hilton was saying something. I don't think.
Oh, I'm sorry.
I said I'm not gonna stick on this right now. I may revisit this in terms of conversation, but go ahead.
Okay, thank you. Go ahead, Steph.
Okay. So that is the extension rule. And if there are there any questions with respect to? I see Mr. Delaney.
Mr. Delaney.
Yes. First off, if I understand correctly, what you did is revisit the existing 201B and bring it into conformity with the changes we've made in the rules, such as capitalizing lots of words because we've now formally defined them. But basically, this is designed, number one, to bring the existing extension rule into the same stylistic pattern that we're using for the new rules. Is that correct?
That's correct. And bring it into alignment with the new law.
Right. And you then removed the 2 sections that you've discussed. But you haven't added anything of any content, correct?
That's correct.
Okay. So my last question is, are you reserving little I, and therefore the text in B1, the last sentence, which says accepted is provided in I through 1 through 4 below, remains 1 through 4 rather than renumbering?
Yes.
Right, that's correct. That was the format that the previous rules. This is the style that the board has adopted throughout these proposed rules. So we kept the format going. Wherever there's a deletion throughout these proposed rules, the board had put down reserved instead of renumbering.
Okay, so we're just adhering to that.
Yes.
Fine, thank you.
And the advantage of that, Ms. Lynn, is just to so that you won't have to renumber, like find places where it may reference those areas all over the place.
I think so. So no, I wasn't here for the beginning of this, but my understanding was that Section 2 is meant to. There's meant to be like an overhaul of Section 2 sometime down the road. This is just a placeholder to try and bring up Section 2 in conformity with the 2019 laws. So then going back and overhauling Section 2 just to fix cross-references would require a huge amount of effort. So for now, we're putting reserved in to keep the cross-references as it is, with the goal down the line that Section 2 is going to be hopefully overhauled at some point.
Sure.
Okay, so with that clarification, I would suggest that the bracket that starts and appears before triple I be moved to be the bracket to begin in front of the word where, because what you're telling me is you're not removing the triple I. So triple I will now read triple I reserved.
Yes, that's a very good point, Mr. Delaney. Thank you for catching that. I think you're absolutely right.
Yes. Are there any other comments or corrections that the board members might have seen when reviewing this document? Okay, so we can move on to the next document. And the next document, at the top of the document, it says section 1-25. It's a 2-page document. Okay, and this document was prepared because the board members, in our discussions with the differences between the procedural rules with the Loft Board and Oath, the Loft Board decided to adopt some of Oath's rules. The language in Oath's rules wanted the Loft Board's rules to mirror that language. So we have 2 sections that we worked on some language that we wanted to bring to the board. The first section is 1-25 for amended pleadings. And on that page at the top in all black, that's the current rule or the old version. And the one below that with some red in there is the new language that Loft Board staff, particularly Tina, worked mostly on this. And we all reviewed it and we all agreed that this language is in essence what the board members wanted to get out of this particular rule. So we this is it. And are there any comments or concerns or questions with this new language for 1-25 related to the amended pleadings?
I need to ask your forbearance for a minute while I get to this document.
Are you talking about momentarily, or you need this put over?
No, I'm talking about momentarily.
Okay, sure.
Okay, are you going to walk us through it?
Sure, I can walk everyone through it. So if the board members remember, the current rule, which is in black, is what we already had. When we're going over the Oath's procedural rules relating to the amended pleadings, the board members wanted us to kind of mirror what Oath's version of the rule. And we didn't put that here, but I can read Oath's amended pleadings. It's 1-25, ironically, it's the same section with Oath, but with respect to amended pleadings, Oath says amendments of pleadings must be made as promptly as possible. If a pleading is to be amended less than 25 days before the commencement of the trial, amendment may only be made only on consent of the parties or by leave of the administrative law judge on motion. So what we tried to do, if you look at the bottom section with the revisions, is we tried to incorporate that language of allowing the parties to be able to amend up into the first conference date. If the parties are going to amend 25 days before that first conference date, then the parties would need consent or the upon motion of the adjudicator. So we're trying to mirror that language. There are some differences between the language oath's procedural rules and our rules. Oath talks about the administrative law judge, and we're saying the adjudicator. Also, oath, their language states 25 days before the date of the trial, and our language says 25 days up to and including, or 25 days before the first conference, because the law board is not, may not necessarily be holding a trial. And also in that rule, we had to also consider Section D of our current rule, which allows this is part B of the corrections that we made. We wanted to make sure that the parties had an opportunity to answer any amended pleading, and we fashioned some language which basically says the adjudicator assigned to the case will afford the applicant or affected party an opportunity to respond to the amended pleadings. So basically the heart of it is the parties can still amend up to, at any time, up to and including 25 days before the first trial. If it's in that window of the first conference. If it's in that window of 25 days before the first conference, then the parties are going to need consent, or they're going to need the permission of the adjudicator. And then after that happens, if the adjudicator, any pleadings that the adjudicator permits, the adjudicator is going to will allow the parties to answer. And after the first conference, the parties must submit amended pleadings only if permitted by the adjudicator. So it's kind of like three sections: before 25 days, before the first conference, then you have a window period, 25 days before the first conference, and then after the first conference. So before, parties can amend at any time. If it's in that window period, 25 days before the first conference, they need consent. And if it's after the first conference, then it can only be permitted by the adjudicator.
Mr. Delaney, did that clarify?
Yes, thank you. That's very helpful.
Any other board members that want any other clarity to this section?
Okay, thank you. So we're finished with that document, and that actually brings us now to the outline.
Mr. Clark, I think we skipped over 1-27C
on
the second page.
I'm too anxious. I'm sorry. Yes, 1-27 is on the second page. And this one is kind of a little bit more straightforward. The new language was recommended by the board members, and also the deleted language was something that the board members suggested. So it should look familiar to everyone. We simply added the parties may be represented by counsel or by a duly authorized representative. And we took out the language that the parties may issue a subpoena, and we left the parties can request that a subpoena be issued. Are there any questions or comments? I'll allow everybody to read it, and if you have any questions or comments, please.
Just a reminder, Mr. Clark, that was on Oath's request?
No, that was the board members when we were reviewing. Oath's language. They thought that our language should mirror some of what Oath had. And there were some questions about who can appear in front of Oath, and the board members said that they wanted a duly authorized representative to also be able to appear.
Right.
And then also there was some confusion about whether or not a party can issue subpoenas on their own. And we just simply took out that language. Mr. Delaney suggested that fix of just taking out issuing subpoenas so there's no confusion. And we left the language that the parties can request that a subpoena be issued.
Thank you.
Okay. Are there any questions about 1-27C? Okay, then we can move to the outline.
Is that the one that says Loft Board draft rules on top?
Yes, the outline says Loft Board draft rules at the top. Okay, and what we did, what was done with this outline is it's a continuation from the outline that we had last month. So you'll see that the first issues all the way up until issue number 19, we've already discussed 1 through 18. That was discussed last month. But we wanted to have a complete outline for the board members. So hopefully it doesn't cause any confusion, but 1 through 18, we've already discussed last month. So we're actually starting at 19 today. Issue number 19, which is section 2-06A. And that first issue, issue number 19, it can be found on page 115 of the rules.
So that's 115 of the big marked up document.
Yes. Okay. If we're all on page 115 and we're on issue number 19 in the outline, you can see that the change that we made was the addition of paragraph 3 on that page. It's in all red. And the added text, it basically guides anybody reading these rules if they had a question about time limitations on filing applications for rent overcharge. We added that reference to section 1-21A4. So that's just added language for anybody that wanted to know about the time limitations on filing rent overcharge applications. We just added that language there so they know what section to go to find it.
So Mr. Clark, just for the edification of the public who's probably don't have this, could you just read the addition language?
Sure. It says, for time limitations on filing applications for rent overcharges, see 29 RCNY section 1-21A4.
Thank you.
Are there any comments or questions about item 19? No.
I have one question. I need a little help here. It's my recollection that the rent stabilization law changes in 2019 affected the time period for overcharge claims.
Yes, I believe
Yes,
so.
it is.
Yeah, and I recall we discussed bringing our rules into conformity with that. Has that been looked at?
Well, I'm not sure if.
We have not. I don't believe that any. I don't know if that discussion was had when current staff was working on these rules. Is that something that was supposed to be addressed?
It's my recollection that it came up tangentially, but it would seem that it would be appropriate for us to try to mirror those changes, or at least look at the difference between what we have and what those changes spelled out, so that if we don't want to bring it into conformity, we have a reason for doing it. I mean, we have a rationale for doing it. I'm inspired by the shark argument of earlier in the day.
Okay, yeah, we can take a look at that. Yes, we'll take a look at that.
Thank you, Mr. Delaney. Are there any other comments or questions?
So is this an open item then, 19, or is this pretty much okay? Just Tina, here's some looking into other things related to it.
Well, so that would be a different section. That would be 1-2184. I'm looking at it now, and right now we limit to 6 years. So we would have to revisit and do some research into 1-2184.
Okay, so as far as this section goes, then we're not. This is not an open thing. This is. Does anyone have any other comments on this, please? Thank you. Go ahead, Mr. Carr.
Thank you. The next item is item number 20. It's also on page 15, and it's some language that there were some questions from the law department as to why we were defining escalators again. So we just modified the language, basically removing the definition from escalators again, because it's already defined in the global definitions. I do see that there's some markouts on 115 under this particular section, but there should be a little bit more. But the language in the outline is actually correct. Instead of on page 115 in the larger packet, the rules, we're deleting after where it says both base rent and escalators. We're going to be deleting everything up until where it says such escalator. So that's something that we will delete, but the language in the outline is exactly what it's going to be changed to.
So again, could you just read that for the record?
Sure.
Just what's changed.
We'll change it to amount of increases. For purpose of these rent guidelines, the following percentages shall be calculated upon the total rent for the residential occupant, including both base rent and escalators. Such escalator provisions that relate to gas, electricity, and steam charges are excluded from this definition of total rent and these utility escalators when based on a fair calculation of the residential occupant's usage, shall be the only escalators permitted following the effective date of the rent increase, provided they were part of the lease or rental agreement in effect on December 21st, 1982. Okay. There are no additional comments or concerns. We'll move on to item number 21, which is on page 116.
It's just that sentence seems a little run on to me. Like, I don't know, this is a very, very long sentence. I'm just wondering So such escalator provisions that relate to gas, electricity, and steam charges are excluded from this definition of total rent. And should that be a comma there then? No, not really. And these utility escalators, when based on fair calculation of the utilities, your residential occupants usage shall be the only escalator permitted through the effective date of the rent increase provided. Is there any way to break that sentence, that long sentence up, guys? Does anyone else have a problem with it? Okay, may I make a suggestion? I don't think it changes anything. Actually, just a comment to a period. But can I? What if we said such escalator provisions that relate to gas, electricity, and steam charges are excluded from this definition of total rent? Period. Right? I mean, can we put something there, a period there, and then we could say these utility escalators, when based on fair calculation of? Is that change anything?
I can't see, just reading it right now. I can't see how that would change the substance of what the rule is trying to say. So I don't see why we couldn't do that.
Yeah.
Period there.
Yeah, thank you. But I just want to make sure. So can I just put a period there now and then read it and see if that to everybody again and see if that, you know, would be a better read, just because this is like 4 sentences in one. So such escalator provisions that relate to gas, electricity, and steam charges are excluded from this definition of total rent, period. Then you take out the word and. These utility escalators, when based on fair calculation of residential occupant usage, shall be the only escalators permitted following the effective date of the rent increase, provided they are part of the lease or total agreement in effect on December 21st, 1982.
Yes, I think that works and breaks up that run-on sentence.
Okay, thank you. So we'll, unless anybody have any more comments.
Yeah, I concur with Mr. Clark. I don't think it changes the meaning. If after more reads on another day we realize it does, we'll bring it back up with the board.
Okay, thank you, Kevin.
I have one other question, and I guess in part it's probably stems from working off this excerpted document, because sometimes the play over the 200 pages of rules can get a little confusing. This is all talking about escalators that were in effect on December 21st of 1982. So that's only relevant to the original loft law as spelled out in 281.1 and 281.4 of the multiple dwelling law. Do we need to, are there, without sitting down and reading through the whole section, is there an equivalent issue that comes up for 281.5 or 281.6?
Yes. So I believe those issues are covered in 2-06.1. Am I? Let's see.
I don't have that, right?
No.
Okay. I don't think the board ever revised those two sections. 2-06.1, 2-06.2, I don't think were ever revised. My understanding is that the board was only revising portions of section 2 that it needed to change. So that's sections that require an updating of the law or a change to the cross references. So there are certain sections of section 2 that are not part of the revisions.
Okay.
So are there any other comments or concerns? Okay, we can move on to item number 21, which is section 2-06.3, found on page 16. This is at the bottom of page 116. For coverage, what we're doing here is we've already defined IMD. So we're using IMD in place of interim multiple dwelling, and also eliminating the reference to MDL 281, which we spoke about, which actually is not necessary because MDL 281 doesn't define IMD. Are there any questions or concerns?
Is there a reason that that you've changed it to this 1, 2, 3 format? Number 3, do not meet the safety and fire protection standards of Article 7B. You also took out of the MDL. Is that perceived as unnecessary?
Yes.
This was actually changed by operations. So I think it's just maybe a stylistic choice by them. So we did not make this change. I believe it conforms with the rest of the section. Now that I'm looking at it, it mirrors how the rest of the section is laid out.
See, Mr. Delaney, the language police does have a real purpose. See?
They certainly seem to have some purpose, yes. Whether it's to make things clearer or more confusing, I'm not always sure. Again, for the layperson, if it said 7B in the MDL, it would be more explicit. But
Well, why can't we put that in? I mean, I don't see a problem with that. Just for clarification. I mean, I don't think there's any other 7B, but you could. I don't think there's a problem with that, right, Stefan?
The law department has went through and removed instances of where we refer back to the MDL. I think this might be a removal from the law department because they felt like it was redundant.
Okay. There you go.
well, I'm not so sure I buy that. I mean, it's not the world's biggest issue, but again, as somebody who spends a lot of time going over these rules with lay people, I know what Article 7B is, but and one would say the informed individual should probably say, oh, well, gee, the law clause Article 7C, so probably 7B refers to something that's also in the MDL. But if it causes the plain language police joy to remove what?
Let's do this. Let's put it back, see if they take it out. Okay, guys?
Are you saying specifically for this section, or wherever they took it, wherever else they might have taken it out?
This section for now. I mean, look, right above that in 1, it says our subject to Article 7C pursuant to MDL.
That's the way it was.
Oh, that's no change to. Yes, but right. All right, so they didn't change 1, right? Okay, let's just, I mean, I don't want to go back throughout the document here, especially since that, let's see if we can sneak this one in. And if what the law department says, if they take it out. All right, it does make it clear.
Okay. Are there any other questions or concerns with 21? Then actually 21 has another section. It's on page 117. Further down, number 4 for garbage escalators. And we actually discussed this last month, but we just changed some of the language there. A little bit more for clarity. We worked on some of the language there. Okay, so are there any questions?
Okay.
Okay. So with that, we'll move on to item number 22, which is section 2-07, sales of improvements on page 119. Okay, at the bottom of page 119, where we're defining unit, we were running into some issues because in this particular section, we wanted to define unit in a way that included sales of improvements that could happen after the building is removed from the loft board's jurisdiction. So specifically, this section is talking about the sale of improvements, and we wanted to include in the definition of a unit sales that can take place after the building was removed from the loft board jurisdiction. Originally, when we brought this to the loft board, the board members' attention, we tried to modify unit and give it a new definition by saying residential. I think we were using. I don't remember what the definition that we were trying to use to replace unit, but what the problem was is wherever we saw unit, it got a little bit confusing on when we should use just regular unit and the new term for unit, which included units that were removed from the loft board jurisdiction. So instead of going back and trying to determine and change unit in all these different sections here, we're just saying unit. We believe that the law department had the main issue and concern with this was that we already have kind of a definition for unit in our rules, and here it says unit as referred to in this rule. So they were confused as to why there's a different definition in this rule. So we changed it from rule to section to be specific that it's just for this section and not the entire rules. So that is the change that we made there. Are there any questions or concerns about that change? Okay. So again, we just tried to be specific that it's for the section and not for the entire rule. So the next item is 23. It's on page 133, section 2-08, coverage, occupants qualifying for protection and issues of status, page 133. And this was a minor change. instead of using the very fun word inter alia, we're replacing it with among other things, which is the same thing. But just for somebody that doesn't know the Latin word, we can just simplify it and just say among other things. Are there any questions or comments about that? Okay, great. So again, under section 2-08, section A2, which is found on page 134. This one, we're just for the term grandfathering, we just modified the wording so that it conforms with the global definition of grandfathering that we already have. We're just making it consistent with the global definition of grandfathering.
Was there anything that makes, was there anything inconsistent in the original language, really? Or was it just seems like a little simplification?
I think, yeah, I would agree. That's more of a simplification, and just making the words match identically.
Okay.
Are there any questions with that change? Okay. There is another change on this page on our outline. It's also section A for III on page 137. Okay, and we just made some minor changes, mostly conforming to capitalizing words that we already have globally defined. But in the beginning of that sentence, it says notwithstanding the foregoing. We deleted that and changed it to in addition to the criteria set forth in subparagraph I of this paragraph. I think that adds clarity and less confusion when people are reading this. So who's the main change there?
Again, that was the law department edit, Mr.
We think it was operations. Recall that we're not sure of who made what changes to these sections.
I see in our new language we have family living independently, all capitalized. Is that now family living independently? Is that a definition unto itself?
It should be.
I don't think it's in the global definitions at the top. I think we define it in section 2, in the beginning of section 2.
Okay.
It's defined there. Okay. Are there any other questions or concerns? Okay, then we can move on to the next change, which is D of the same issue. And it can be found on page 139. It's section A for 4A. So this change we just actually some language was actually included. It's the language from MDL section 4 37, which defines a cellar. Instead of just saying the cellar should not be located in a cellar such as such term is defined in MDL section 437, the new language actually includes MDL section 437's definition of cellar. And so give everyone some time to look at that. Jared, any questions or comments? I see everybody. I see everyone still reading. Okay. If there are no questions or comments with that additional language there, basically writing out the definition of cellar as defined in MDL 4, section 437, we can move on to the next section. And that can be found on page 140. That's section A5 on this page. This pertains to the study area. And we just, the language was just modified for clarity. I'll give everybody a chance to read that. Are there any questions or comments with the way that it reads now? Okay, and the next one is section C7, page 145. And again, this is just some language for clarity. If you look at the original text, and then what it's changed to, the hope is that it's cleaner and reads, is a little bit less confusing for people that read this. So give everyone a quick second to look over. And if there are any issues or any comments, please let us know.
Oh, I just want to make it clear. There's no these dates remain the same, right? These dates weren't affected by. I mean, we're not changing any of these deadline dates or anything like that. They weren't affected,
No.
right? Okay.
Yeah,
So
this should be.
This is strictly transparency and clarity stuff. Right?
Correct. Okay. If there are no comments or concerns, then we're finished with everything we have with respect to rulemaking to bring to the board. So we do have a couple of things that were mentioned today that we need to get some clarification on. The two that I remember off the top of my head is going back to the law department and finding out if we can include table of contents. What is the reason why? And also to I'll check. Well, we'll leave the MDL in one section, and then there was a question about bringing the time to file an application for rent overcharge into conformity with the new rent laws. So we'll double check that as well. And I'll review my notes, and we'll all review our notes and get back to the board. But with respect to everything that we needed to bring to the board member, we have officially brought them to the board. Congratulations. It's been a long, very long haul, but
thank you.
We're waiting for this moment.
All right, Stefan, that was remarkable. I really appreciate this. I mean, this seems like, you know, I don't know if anybody's on the high that I'm on, but I really do appreciate your efforts here. So obviously we'll get back next month on those two or three minor clarification issues with the law department. And when is the party? I mean, come on, Kevin, you're specific.
Yeah. Party planning was in the job description, right? That's
Okay.
I got here just in time. Yeah, no, we're you know, this is great to be so close. We'll definitely be checking those last things out, and then we'll party.
Okay, that's a good answer.
Mr.
Go ahead, Mr. Barrow.
I have a couple of nitpicking things on the full document, New York City Loft Board, notice of public hearing, an opportunity to come on and propose rules. On page 27, and I think I had mentioned this before, the word adjudicator is diminished and hearing officer is used. And on page 8, hearing officer is used, in which case you're really talking about the oath judge. So I don't understand why that language was put in there. We made a, you know, I think I had mentioned to you previously, I didn't like that term adjudicator, but okay, it's there. It's all over the place. But now when we're talking about the oath judge, we're calling him a hearing officer.
Yeah, I mean, I vaguely remember the fact that the word adjudicator is what was refers to the old Loft Board term when the Loft Board was doing these hearings, right? Or doing their own hearings. Oath, in order to differentiate between when it's done an oath or when these rules refer to a Loft Board person doing it, the word hearing officer is what the oath judge the oath uses. So whenever you see adjudicator, correct me if I'm wrong, Stefan, whenever you see the word adjudicator, it is referring to any instance where the Loft Board would be doing such adjudication. Stefan, you're muted.
I'm sorry. Yes. The way that the adjudicator is defined, it encompasses an administrative law judge or hearing officer. So adjudicator can mean either of those. And the reason why we leave it as adjudicator is just in case the law board ever goes back to conducting our own trials and hearings, we don't have to change the language. But as Chairperson Hilton said, if it does say hearing officer, it is something that is in front of a tribunal, such as oath, where there's a hearing officer conducting the hearing or the trial. So that's the difference. One is leaving it open so that
talking about the oath judge, we now call him the hearing officer?
Yes, they're administrative. They're called hearing officers. They're called administrative law judges, and also they can be an adjudicator.
All right, I give up. I will send you a little message about some of the other things. On page 48, device is spelled wrong. There's a Y in there, it shouldn't be.
48?
There's an R in device.
Mr. Barnes, could you just go back to what you said, 48, page 48?
Page 48.
And you said the word device is spelled wrong?
It's spelled wrong.
So am I looking, because on my page 48, it seems like everything is crossed out here.
Well, let me.
Yeah, that's what my page 48 looks like as well. It might be a different version Mr. Barowitz is looking at, but on my page 48, everything is deleted.
I think it would be great if we could get a new version that everybody could use that's maybe a PDF so it stays the same. And I know I want to read over everything, excuse my squeaking, from beginning to end, because doing these pullouts has been expeditious, and I don't object to it. But before we vote to publish this, I'd like to have the opportunity to go from page 1 through the end and be able to flip back and forth, and we could all have everything on the same page. So Elliot's 48 is my 48 as well.
Right. So we agree, and we're going to be doing a final draft.
My problem is that when I produced the document on my laptop, and then when I produced it on my big screen, they didn't come out as the same pages.
Okay, all right, so which page are you,
I just have one more thing, which I had mentioned once before.
I'm sorry, Mr. Bowers, before you go on, I just need to know if the word device somewhere is spelled wrong.
It's spelled with an R somewhere.
Oh, okay. Could you,
I can't even find it on page 48.
Just do a word search at some point, make sure that the word device is spelled right.
I have a couple of other small points, but the other point, I think that I tried to say this previously. I'm not an expert grammarian, but pre-certified in one word is not really a word. And you can't pre-certify something that is certified. The word certified means that it's a past tense, it's done. So you can't pre it. So probably the word would be pre-certification.
Where are we talking now?
Now that I find on page 71. And it's used on page 72 4 times.
Okay, so you couldn't just say interchange pre-certify and pre-certification because one is a verb and one is a noun. So we have to find out how we would change that language. Let me just see what you're talking about. Are you guys identifying it anywhere?
All right, I have a couple other things, but I'll
wait, Mr. Bowers, we have to kind of debate it.
I'll send a note to Stephanie.
Let's identify what you just talked about so we can address it on the record.
Yeah, I see them all. It's in section B and section C.
Somebody point it to me, please. If you,
All right, for instance, on page 72, on the very last paragraph,
does it exist on page 71?
Yes,
Just-
in three little I, big capital A, if the application is not pre-certified. Third paragraph from the bottom.
Stefan, do you, I mean, I'm not, I don't know where I'm looking. I'm not finding it.
Is anyone, Tina, are you working with a digital version by any chance right now? You could search
Yeah,
for
I
the word
see it on my page
pre-certified.
71. It's
You
on
see
my
it on
page
your page
71.
71?
I'm seeing exactly what the others are seeing.
What can you give a citation that the rest of us can go to? Because I feel like those on paper aren't seeing it the same way.
So it's 2-01, section 7, paragraph 2 of subdivision I of section 2-01. And it's a few pages in until you get to triple I.
The clearest language would be has not been certified.
Right. So, Mr. Barrows, this is all language that's from our existing rules right now. So if we want to go back and change stuff in section 2, we can certainly do that. As I mentioned, we're trying to do as little changes to section 2 as possible in the anticipation that there's going to be an overhaul down the line. So just so you're aware, that's where this language is coming from. It's part of our current existing rules.
Okay.
So, Ms. Lynn, so you, meaning that this language exists right now, it has been existing forever, Mr. Barnes, maybe before the language police ever was invented. And so we don't want to mess, because we're going to be looking at those rules later. So if we can tolerate just leaving step for now until we tackle chapter 2 in its entirety. Is that okay, Mr. Barr? Okay, did you have any other, you said you had something else?
I'll send an email to Stefan.
Okay, thank you.
You'll
That's
love
fine,
it.
you know, we are coasting, so we have, you know, we can take some other questions if you have. But I appreciate that. Obviously, if there's any substantive stuff, we'll bring it back to the board. We're not gonna, if there's a spelling error and as long as the dictionary agrees with us, we'll make those changes.
Yes. And like as I was saying before, we will make a final version with all of the edits and all of the changes in one document. And we'll try to get that to the board members as quickly as possible so they can review it one more time.
Okay, thank you. And could you PDF that version?
Sure.
Okay, is everyone satisfied and pretty much all hearts are clear on the rules right now where we stand? This is we've gone through all the revisions and comments back from law and oath and also operations. And we believe that we've covered just about everything with those few exceptions that we just mentioned that we'll clarify for next meeting. Apart from that, we maybe Kevin or Tina, could you enlighten us on where we'll go for next month as it pertains to rules?
I mean, I think, oh, Tina, yes, please.
I spoke too soon. Okay. Yeah, so the plan right now is, as Stefan mentioned, for us to deliver a cleaned up version of the rules so the board members have the opportunity to review everything in full. We're hoping to be able to do that in the next couple of weeks, fingers crossed. So the board will have 2 weeks to review the rules before the May meeting. We'll also get some answers on those 2 outstanding items that the board had raised during this meeting. And hopefully, if nothing else is, amiss, we can send it out in May. The board can decide to send it back to the law department. But that's, of course, assuming that everything looks okay to the board.
So in other words, Ms. Lynn, if we are able next month to vote on a final draft of this rule, we can do that if we're able to agree on, we can vote on a final draft of this rule next month, at which point we will send it over to the law department for review and what do you call that, initial certification?
Yes. Mm-hmm.
Absent any significant, any comments, significant comments that the law department may have that may need to come back to you. There may be substantive stuff, and there may be just other stuff that doesn't really need to come back to the board, like a numbering issue. And so I think we just, I just really am proud of the staff and the efforts that has gone into these rules for the past 4 years. And we are confident that that we can move forward. I just want to let you know it is the chair's desire to move forward. I mean, I say chair, I'm not talking about myself, I'm just here, but the chair, we do need to move these things forward and put an end, a conclusion to this effort. You may have also noticed that you have a light calendar of cases, and that was by design. So this way we can focus on these rules and completion of these rules. So, are there any other comments from any board member that we need to consider here today before we close the meeting? Any issues or any concerns?
So we have no idea whether the meeting will be in person or Zoom next month.
That's correct. That's correct. Because the governor hasn't yet given us our next meeting. I'm going to read that in the closing, but the governor yet hasn't. We can only do this 30 days at a time, so the next extension doesn't cover our next board meeting. But as I said, if you play the lottery, you should probably play it on not being in person next time. Okay. I don't see any hands up or anything like that, so I'm going to read. This will conclude our April 15th, 2021 Loft Board meeting. Our next public meeting will be held on Thursday, May 20th, 2021 at 2 p.m. The governor's suspension of in-person meeting requirement of open meetings law is in effect until May 6th of 2021. So at this time, we do not yet know whether we will be permitted to hold a May 20th board meeting virtually. When we do know the format of the next meeting, we will update the public through the website and on the Loft Board listserv. And board members, you will be made aware. Board members, please sign and email in your attendance sheets. And I want to say to everyone, have a good afternoon. Thank you.
Thank you, everyone. Thank you.
Thank you.
So long.
So long, everyone.
Bye.